Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good day,
Waalaikumsalam warahmatullahi wabarakatuh.
Good day, ladies and gentlemen, and also the participant of International Seminar on United Nations Convention on the Law of the Sea on Wednesday, 19 November 2020. My name is Arini Askamutia, junior lecturer at Faculty of Law, University of Bengkulu. Personally, it is such an honor to me moderating this seminar. As known, this international seminar is organized by Faculty of Law, University of Bengkulu. This is an annual event hosted by us to enhance the understanding of scholars across the world and Indonesia, particularly to discuss and debate and share view about the current issue that we face together. Ladies and gentlemen, and also all participants, before we proceed this event, I inform you some guidance. First, this seminar will discuss concerning to the United Nations Convention on the Law of the Sea. This event will be moderated by me and hosted by Adrian. Both of us have authority to turn your microphone on and off. Second, or presentation delivered by panel speakers, and second, question and answer session. Third, conclusion made by each speaker. Third, we allow the participant to write the question down into the chat box. I will pick some then. It will be answered by the panel speaker. So please make your questions short, precise, and concise. And do not forget to identify yourself by writing your name, citizenship if you come from overseas, and also your institution background. Or if you want to ask directly to panelists, just press the raise hand button. Our committee will notice you, then the microphone will be given to you. Participants joining us through YouTube channel also can be involved by putting your question into comment box. We also ask all participants to fill their name in the list of attendance of presidency because the certificate only will be given to the people who attend and join this event from beginning until the end. And the last, the list of attendance link will be shared into the chat box as well as in the comment box of YouTube channel around 10 minutes before the event international seminar dismissed. The honorable speaker, Prof. Robert, Prof. Otto, Mr. Valentin, Mr. Emma, and Vice Dean. Before we start the international seminar, we will listen first to the opening remarks from the Vice Dean of Academic Fields, Faculty of Law, University of Bengkulu, Dr. Chandra Irawan. Dr. Chandra Irawan, time is yours.
Okay, thank you, Ibu Arini Askamutia. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, all of you. On behalf of Faculty of Law, Universitas Bengkulu, I have the respect to the speakers in this seminar, Professor Robert Sebekman from National University of Singapore, Mr. Dr. Otto Speaker from Wuhan University, Mr. Valentin Schwartz from Universitat Hamburg, and Mrs. Emma Septaria from Faculty of Law, Universitas Bengkulu. PhD candidate in University of Jambi. Maybe coming soon, Miss Emma. Ladies and gentlemen, my dean apologizes to all of you because our dean have to follow another agenda in the Constitutional Court, Republic of Indonesia. Ladies and gentlemen, speaker and all participants in this seminar, first of all, allow me to say my gratitude to Allah Subhanahu wa Ta'ala, giving us the help amid all the pandemic so that we can join and participate in this conference, in this seminar. Then I would like to convey my highly appreciation of the committees who have already well organized in this international seminar on United Nations Convention of the Law of the Sea. It is the second international seminar hosted by Faculty of Law, Universitas Bengkulu. Previously, we have successfully held international conference on law, environment, culture, and globalization. Moreover, I also appreciate and welcome a prominent speaker who I surely believe that will enrich and fit our breakthroughs in his presentation after this session. Ladies and gentlemen, and all respected participants, since the end of the Second War, no brand international law has undergone more profound and revolutionary change than the law of the sea. The law of the sea has undergone profound change according to the time. This is because the sort of mineral oil contained in the seabed itself, it is a link between nations from a sector of human activity and the world of biological resources, and 70% of the Earth's surface consists of the sea. I think Indonesia should be proud because Indonesia has become an important part to changing the international law of the sea through the Juanda Declaration. 25 years after the Juanda Declaration, UNCLOS 1982 was born and contained in the rule of in the Juanda Declaration. However, even though it has been regulated in such a way, problems around in this still occur and are even more prevalent lately, such as illegal fishing, issues of sovereignty, maritime boundaries, and many more. The most recent and closest conflict with the region regarding sea issues in the South China Sea conflict. The South China Sea includes water and land from the archipelago of two large islands, the Spratly and Paracel, as well as the marsh of the Musclesville River and Scarborough River, which stages as the west of the Musclesville River and Scarborough River stretches from Singapore, starting from the Malacca Strait to the Taiwan Strait. To this vast expanse of territory and his history of obtaining control by the traditional rule of our neighbor country. Today, several countries such the Republic of China, Taiwan, Vietnam, the Philippines, and Brunei Darussalam are engaged in confrontational effort of mutual claim over part of all of the South China Sea. Indonesia, which is not a climate state now, became informed after the People's Republic of China claimed to the water of the South China Sea emerged in 2020. It is such a big problem from the UNCLOS can solve. The seminar is expected to be able to explain and answer the problem about the sea and how the role of UNCLOS in facing the problem. The seminar is also expected to be able to provide input to Indonesian government in terms of drafting regulation related to marine issues. Ladies and gentlemen, today, this forum attended by many stakeholders, policymakers, government officials, professors, scholars, students, and also representatives of NGOs. I hope this seminar will contribute many ideas, solutions, and also recommendations. Closing this opening ceremony, I say all of you welcome to the Faculty of Law Universitas Bengkulu. Enjoy this seminar. Terima kasih. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you for Dr. Chandra Irawan. So now, as air traffic control in this panel discussion, I have adapted to introduce our distinguished speaker. We are fortunate today because we have presenters who are very expert in the field of the law of the sea. Our first speaker is Mr. Valentin. Mr. Valentin is a research associate and PhD candidate at the chair of International Law of the Sea and International Environmental Law, Public International Law, and Public Law of Professor Alexander Prols, and a member of the Institute for the Law of the Sea and for Maritime Law. Mr. Valentin is recipient of the Diploma of the Hague Academy of International Law in 2020. And our second speaker is Prof. Robert. Prof. Robert Beckman is an Aegis Senior Fellow in the Maritime Security Program at the Institute for Defense and Strategic Studies of the Rajaratnam School of International Studies, NTU. He was the founding director of the Center for International Law, University Level Research Center at the National University of Singapore. Our third speaker is Prof. Otto. Prof. Otto is Professor of International Law at the China Institute of Boundary and Ocean Studies, Wuhan University. He is also a member of the Committee on the Role of International Law in Sustainable Natural Resources Management for Development of the International Law Association. And our last speaker, lady, Miss Emma Septaria, one and only. Miss Emma is a lecturer at Faculty of Law, University of Bengkulu, and Doctor Candidate of Universitas Jambi, Indonesia. She is a member of Indonesian Society of International Law Lecturer. Her research interests include law of the sea, international environmental law. And distinguished guests and all participants, without further ado, Mr. Valentin will talk on historic fishing rights in EEZ and archipelagic waters. So 20 minutes ahead is yours, Mr. Valentin. Feel free to use share screen and microphone. Thank you.
Thank you kindly for this nice introduction and also for the invitation to this seminar. First of all, I want to apologize to the other speakers for this slight change in the order of speakers, which is due to a discussion, a governmental discussion that I have directly after this event. So I have to leave on time. Let me briefly share my screen so that I can, so that I can start with my presentation. Do you all see it quite well? I assume so.
Yes.
So let me start. I've been asked to talk about historic fishing rights in the EEZ and in archipelagic waters specifically. So I will devote my time to these two maritime zones, although of course the topic of historic fishing rights is also relevant in other maritime zones such as the territorial sea or the internal waters or even the continental shelf. Just very briefly, there are several maritime zones of coastal states in which they enjoy rights to fisheries. These are the internal waters, the territorial sea, the exclusive economic zone, and to the extent that sedentary species are concerned, the continental shelf, and of course also the extended continental shelf. The role that historic fishing rights play in this regard is one of fisheries access. So in other words, historic fishing rights are one way by which other states, non-coastal states, can claim a right to access to the maritime zones of coastal states. Other forms of access, or in fact, the far more common forms of access are simply bilateral or multilateral fisheries access agreements, such as, for example, the arrangements in the common fisheries policy of the European Union between EU member states, for example. Now, before I start, historic fishing rights are, I should mention that historic fishing rights are an extremely contentious concept. So many of the things that I might say today might not represent universal recognition among scholars or states. So please be aware of the fact that there are many different conflicting opinions about this doctrine, its different aspects, and the extent to which it can still be used nowadays. I belong to the group of scholars who take a relatively restrictive approach to historic fishing rights, and I think that the concept is widely overused both by states and scholars. And I think in practice, in my view, and based on my own research, historic fishing rights or traditional fishing rights do not really play a very important role, if they play a role at all, beyond certain political arguments or jurisprudence of a few arbitral tribunals. Now, in my view, and this is already contentious, historic fishing rights are prescriptive rights of states to fish in a coastal state's waters. And there's a lot of inconsistent use of terms. So you will come across the terms customary rights, traditional fishing rights, indigenous fishing rights, historic fishing rights, traditional fishing rights, and so on. And very often they don't refer to the same thing. They could refer to rights granted under domestic law. They could refer to rights granted in a treaty, or in some cases, they will in fact refer to actual historic fishing rights in the strict sense, which are rights under customary international law, not treaty-based rights. They are also legal rights in the strict sense, but often you will find that in diplomatic discourse or in political discourse, the term traditional fishing rights or historic fishing rights will in fact be used with respect to historic fishing interests, which are not legal rights in the strict sense. What is important here is that historic fishing rights are not rights granted by explicit consent, like an access agreement, but these are rights that are acquired by implicit consent. And their relevance has changed a lot in the 20th century, and I will show you a few slides after this to show why, because of the huge change in the extent and nature of coastal state fishing rights that pushed foreign and even neighboring fishing fleets far out to the sea, and that led to a growing demand for continued access, or at least from a political perspective, by these other states. At the same time, coastal states nowadays don't need to rely on doctrines such as historic fishing rights to justify their own exclusive access of their coasts, because these older concepts of historic fishing rights that you might find in older jurisprudence and older textbooks was being used mostly by coastal states to justify access to fisheries that are nowadays easily within either the territorial sea or the exclusive economic zone of these states. If we agree that historic fishing rights are prescriptive rights of states, then they have two main legal requirements. The first one being that the state claiming such rights must exercise an exceptional claim, such as fishing in another state's maritime zone without that state's consent. Exceptional meaning, in essence, that the claim is adverse, it's unlawful in a sense, it lacks the consent that it would otherwise require. This then leads to a need of the coastal state to protest that unlawful conduct or that exceptional claim. And if it does not do so, this can lead to acquiescence on behalf of the coastal state, which is a form of implicit consent. And this acquiescence will then eventually lead to the generation of a historic fishing right that will be limited in its scope to the scope of the claim that has been exercised, not beyond that. I will get to the relevance of these points with regard to the EZ and archipelagic waters in a minute. Now, just to visualize the problem, so before the 1960s, the accepted extent of exclusive fishing rights of coastal states was 3 nautical miles. It was only the territorial sea, and other states were allowed to fish close to that coastal state's shore. Now, in the 1960s, the concept of the exclusive fisheries zone of 12 nautical miles emerged. And if you look at state practice of that time, it is very clear that this was a zone of exclusive fishing rights, and coastal states could phase out the fishing of other states. In the 1970s, coastal state jurisdiction and sovereign rights grew even further. Even prior UNCLOS, the concept of the exclusive fisheries zone of 200 nautical miles was accepted and became a rule of customary international law. And in UNCLOS, the territorial sea was also extended to 12 nautical miles. In addition, as you all know, the concept of the archipelagic waters was recognized, which gave coastal states, or archipelagic states rather, additional rights. Now, just a second. Now, there are 2 big questions that are being discussed or in the literature, but also in the jurisprudence that have been in the focus of discussions. And these 2 questions being, first of all, did historic fishing rights exist in high seas areas prior to UNCLOS, or even prior to the expansion of maritime zones under customary international law? And second, assuming for the sake of argument that there have been such rights, are they compatible with UNCLOS? And if not, are they preserved or are they extinguished by UNCLOS? Let me deal with the first question first, because it concerns both the EZ and archipelagic waters. As I said, the claim that the non-coastal state exercises must be exceptional, which means that, quite obviously, it's virtually impossible to acquire historic fishing rights that are non-exclusive in the high seas, because there was freedom of fishing, and that rendered any fishing activity lawful, or not any, but most fishing activities lawful in the high seas, and there was no basis for protest by other states or acquiescence by other states. So there's really, under international law, no reason, if you agree that it is a consent-based system where rules don't just somehow magically appear, there was really no reason for historic fishing rights, at least non-exclusive historic fishing rights, to be acquired on the high seas. This was also not, or this result is not, does not contradict the ICJ's own jurisprudence in the fisheries jurisdiction cases, although some people think so. But if you look at that judgment closely, it deals with a legal situation where the freedom of fishing in the high seas was not yet replaced by the EEZ. And therefore, the finding of the ICJ that there are still some sort of traditional fishing rights appears to be a reference to traditionally exercised high seas freedoms that need to be balanced against preferential coastal state rights that at this stage were not yet exclusive. Now, the ICJ confirmed this view that I'm presenting here in its Gulf of Maine case in 1984, where it said that in high seas areas you cannot acquire, or not normally acquire, historic fishing rights. And this was unfortunately rejected in the Eritrea-Yemen arbitration in the 1990s, although it must be said that that arbitral tribunal really did not create a particularly convincing precedent, in a sense, because it did not reason its decision with respect to international law when it talked about traditional fishing rights. And it did not engage properly with UNCLOS or state practice. And there are also some aspects of the arbitral tribunal's applicable law clauses that it had to apply that justify distinguishing it from proper public international law, UNCLOS-based jurisprudence. Now, in the famous South China Sea arbitration, and there mostly in its award of on the merits, there are interestingly two views that are being advanced. One being that one following the ICJ's jurisprudence with respect to areas beyond 12 nautical miles, but interestingly rejecting the ICJ's view without, however, arguing this properly with respect to areas within 12 nautical miles. But I'm not talking about areas within 12 nautical miles today, because the territorial sea is out of the scope of this presentation. Now, regarding the EEZ, after what I've just said, it's merely a hypothetical question whether UNCLOS is compatible with historic fishing rights in the EEZ, because there in the first place were no such rights in probably all cases. Now, there are some people who argue that this doesn't really, or assuming for the sake of argument that there were such rights, and actually looking at the question of compatibility, there are some people who argue that the 8th recital of the preamble of UNCLOS somehow says that UNCLOS does not deal with historic fishing rights, and therefore UNCLOS leaves them untouched. However, if you look closely at that clause of the preamble, it just says that matters not regulated by UNCLOS fall outside its scope. And the question of access to fisheries and fisheries rights is clearly regulated in UNCLOS, and with respect to the EEZ in Part 5 of UNCLOS. It says, Part 5 of UNCLOS says in Article 56, as we all know, that there are exclusive or almost exclusive sovereign rights of coastal states to fisheries. There are explicit rules on access in Article 62. These rules even account for the issue of habitual fishing by other states, but they don't give other states a right to access. This is just an aspect that needs to be taken into account by coastal states when they have a surplus that they can share. Now, after a careful analysis, and of course, due to time reasons, I cannot be more in detail. Sorry, I can't hear you. Just my screen just was unshared, I think. Is that correct? Can you still see my screen? Okay, I think it's back now, right? Okay, I'll speed up, don't worry. After what I've just said, and if you said something, moderator, please unmute your microphone, because I couldn't hear anything. The historic fishing rights are clearly incompatible with Part 5 of UNCLOS, and since this is the later rule and a treaty rule, it extinguishes any hypothetical historic fishing rights. Also, what is often forgotten, there's very clear practice of states that points to a phasing out of access even where there has been traditional fishing. So, and that is often ignored, unfortunately, in the discussion. Now, I'll skip the question of whether there can be historic fishing rights that are acquired post-UNCLOS. Maybe that we can address that in the discussion. Let me quickly and very briefly turn to this archipelagic waters. Here, the basic legal questions are largely the same. There can't have been any historic fishing rights in high seas areas that are now covered by archipelagic waters. However, there are some explicit provisions in UNCLOS that deal with so-called traditional rights, which are Article 47, paragraph 6, and Article 51, paragraph 1. And at least the latter of the two definitely covers fishing interests of immediately adjacent neighboring states. Now, what is important here is that the rights envisaged by these provisions are not historic fishing rights in the strict sense. They don't refer to rights that have pre-existed in the strict sense under the law. Rather, in my view at least, these are treaty-based rights, and they are the result of negotiations, and they refer to fishing interests that were exercised by exercising the freedom of fishing in areas that are now archipelagic waters. So in other words, they are somehow grandfathering rights that with respect to the freedom of fishing on the high seas of certain immediately neighboring states. That term is very narrow, and it only covers states that have a maritime boundary with the archipelagic state, which means that all other states, which are not immediately adjacent neighboring states, do, a contrario, not have any traditional fishing rights under UNCLOS. And if they hypothetically had some, they would be extinguished by UNCLOS. Also, I think we can use these provisions, which are from part 4 of UNCLOS, to argue, a contrario, that there are in fact no historic fishing rights in the other maritime zones, because this issue was clearly being dealt with in the negotiations, and the decision of the drafters of UNCLOS was apparently to only grandfather those high seas fishing rights in the archipelagic waters. So I think this is a strong a contrario, systematic a contrario argument against historic fishing rights in the UNCLOS context. Now I see that I've already used up 19 minutes. So let me conclude this brief presentation, and thank you very much for your attention. I'm looking forward to questions that perhaps will give me the chance to delve into some details later on. Thank you very much.
Thank you for your amazing presentation, Mr. Valentin. It was very deep explanation. And now time to hear the presentation from Prof. Otto. Then after Prof. Otto give the presentation, then we go to Prof. Beckman, then we'll be closed by Bu Emma. Prof. Otto, 20 minutes is yours. Thank you.
Yes, thank you very much. It's a great honor and a great pleasure for me to address all of you. I'm sorry that a bit like the previous speaker, I have to leave after the presentation. So I will try to be brief and then maybe allow some room for questions, a couple of questions. But if you have any questions after this meeting is over, you can also contact me, that is fine. So I have prepared a presentation, but I asked Ari to show the slides. I don't see them, so I will wait. Yes, that looks familiar. Okay. They are not very sharp, but I hope you can all see them, at least a little bit. I'm not sure what's going on.
Can you see the share screen? Bisa dilihat nggak share screen?
Yes, we can see the screen, Pak Rio. First screen, yes.
Okay, so I will just begin then, I guess.
Yeah.
Okay, so, yes, so my presentation is about the link between the international law of the sea, more specifically the Law of the Sea Convention that was concluded in 1982, and the Sustainable Development Goals that have been adopted in 2015. So that is what I was asked to talk about. So that will be the topic of my presentation. It's important to emphasize that already before the adoption of the Sustainable Development Goals, so by the time that the international community set itself the task to write them, they gave themselves the assignment, but this we cannot read. Is there not a way to show the slides so that people can actually read them?
I think the connection from the Aryo is not really good, so we can fix the technical. But please continue your presentation, Otto.
Yeah, okay. Yes. But I kind of need my presentation. Okay, anyway. So in 2012, the international community set itself the task to draft a limited number of, yeah, this is fine, of sustainable development goals. Because the Millennium Development Goals were set to expire in 2015. And already at the outset, there was this commitment, and now I quote, my slides have disappeared again.
We try to accomplish the difficulties soon.
But it looked fine. Yes. Okay, so the international community set itself to protect, restore the health and productivity of oceans and marine ecosystems, and put emphasis on the protection and preservation of biodiversity and of the sustainable use for the benefit of both present and future generations of the resources of the marine environment. So, and to protect it from the threats caused by humankind. The most important is, of course, pollution. Introduction of plastic into the ocean is a big issue. But also other types of pollution that are maybe less obvious, like noise and light pollution. And also the introduction of alien species in parts of the sea where they do not belong. But the idea was not so much to protect the oceans from us, humankind, but rather to allow for it to be used sustainably. So the marine environment was still seen as a natural resource for the benefit of humankind, but we had to use it in a way that also future generations can make use. Please do the next slide. Next slide, please. Oh yeah. So yeah, this is the one, SDG 14. So in the end, the ocean goal is a Sustainable Development Goal 14. And what is striking, and that is what most of my research has concentrated on, is the almost exact language used in SDG 14, which is almost exactly the same as some of the language we find in the relevant provisions of the UN Law of the Sea Convention. And this is quite exceptional because I also did some research, for example, on the water goal, SDG 6, but there we do not find such clear connection with already existing international law. So if you look at the different targets of SDG 14, you can quite clearly link them to specific provisions in the Law of the Sea Convention. And that is what I tried to do in my PowerPoint. So maybe I can share this PowerPoint with the audience and then they can have a look at it after. So for example, target 14.1 can be linked to Article 194 on the reduction of pollution, but there target 14.2 is then more linked to relevant provisions on the protection of the marine ecosystem and so on. Please do the next slide. Yes. So after the SDGs were adopted, the interesting question was, okay, so what is the next step? And very early after the adoption, so already 2 years afterwards, a conference was organized especially on Sustainable Development Goal 14. And the conservation and sustainable use of the ocean, seas, and marine resource for sustainable development was the sole topic that was on the table at this conference. And this led to an outcome document in 2017, which is not that well known, but it sort of emphasizes the importance of the SDG 14, of the realization of SDG 14. But the most interesting next development is, of course, the drafting of this international legal instrument, the ILB, on the use and on the protection of the biodiversity in areas beyond any state's national jurisdiction. So this is something, a treaty that the international community has been working on for the last couple of years. And we have been monitoring that process very carefully. And it's a very slow process. And some people that are very closely involved in that process, they have begun slowly to complain about the tardiness of the process. So basically, the aim of this process is to conclude a treaty, a new international legal agreement, solely on the protection of biodiversity in areas beyond any state's national jurisdiction, so i.e. on the high seas. So why is that so interesting, and why are these resources in such need of protection? Well, it's because we are losing marine species day by day, basically. And so much of the ocean we don't know yet. So we are now destroying species of life and of plant that we have not even discovered. And this is, of course, a tragedy, both in the environmental sense, but it's also a tragedy because a lot of genetic resources are being lost that could have potential benefit for us to make medicine and to learn from in a more general sense. So a lot of resources are getting lost even before we actually manage to find them. And this is something that is of great alarm, should be of great alarm to the international community. So the efforts at achieving SDG 14, they are now focused on this biodiversity issue and the conclusion of this new treaty. That is sort of what I wanted to share with you. Sorry that it was all a bit chaotic. I would kindly ask Ari to share the PowerPoint with everybody. That's fine by me. Maybe that will make my presentation a bit clearer. So I now look forward to any questions that you may have, and the moderator can please cut me short when my time is up. Thank you.
Okay, thank you, Prof. Otto, for the amazing presentation. And we look that you are using batik right now. We are very honored. Such a nice batik, Prof. Thank you. And now we next to the presenter, Prof. Robert Beckman. Prof. Robert brings on the table the issue of the limitation of Southeast Asian maritime boundaries. Without further ado, I call Prof. Robert Beckman. The time allocation is the same, Prof. 20 minutes. The microphone is yours.
Thank you very much. I'm wondering whether, is Ari put my slides up? I thought I was going to share them. Are these my slides? Can you see my screen? I'm not sure.
Yes, we can see the screen, Prof.
Prof,
Okay.
just say next, yeah, Prof.
All right.
Change the slide.
Okay, I'd just like to, well, again, if I think I shared, it might be clearer. I think if I share the slides, they might be easier for everyone to see because I might have stronger internet. Okay. Can you see my slides now?
Yes. Yes, we can see it clearly.
Okay. All right. Thank you very much. It's my pleasure to be with you this afternoon. It's my first trip to Bengkulu. Although I've been in Southeast Asia for more than 40 years. I'm going to be looking at some of the delimitation of boundary issues in Southeast Asia. I'm first going to be looking at, I'm taking a historical perspective. Boundary delimitation was not an issue before the 1958 conventions because there was only a territorial sea of 3 nautical miles. So there weren't many boundaries that overlapped. So I'm going to look first after the 1958 conventions on the territorial sea and continental shelf. And the next part is to look at boundary delimitation after the 1982 UN Convention on Law of the Sea. And then the third part is to talk about obstacles to the delimitation of boundaries in the South China Sea. Okay, part one, delimitation in Southeast Asia after the 58 conventions. Again, prior to World War II, as I said, those coastal states could claim sovereignty over a belt of sea adjacent to their coast called the territorial sea, but the major powers would not recognize a territorial sea of more than 3 nautical miles. All sea areas outside of 3 nautical miles were high seas, subject to the principle of freedom of the seas. The big powers wanted to limit the territorial sea to 3 nautical miles because that ensured there was a belt of high seas through all the major sea lanes of communication. For example, during the colonial period, before the Juanda Declaration, Indonesia simply had a 3-mile territorial sea around all of its islands, and all the water between the islands was high seas. This, of course, with only a 3-mile territorial sea, ensured that the 3 choke points between the Indian Ocean and the South China Sea and East Asia had a belt of high seas between them so that the ships could go through the Malacca Strait or the Sunda or Lombok Straits and not enter waters under the sovereignty of Indonesia, Malaysia, or Singapore. That's why the Soviet Union and America insisted on not recognizing more than a 3-mile territorial sea until very late in the negotiations. Now, Indonesia started in '57 with the Juanda Declaration. Other developing countries also claim more than 3 miles. But in the Geneva Conventions of '58, there were 4 conventions. I'll just mention 2 of them. The one on the territorial sea established rules governing the territorial sea, but they couldn't agree on the breadth of the territorial sea. They had a second conference in 1960 to try to resolve the problem of the breadth of the territorial sea. They could not reach agreement. Therefore, there was a great deal of inconsistent state practice, and many developing countries started to claim more than 3 miles, some claimed 12, some Latin Americans started to claim 200 for a territorial sea. So there was a great deal of confusion on breadth of the territorial seas. The '58 convention also recognized that coastal states had a right to claim a continental shelf adjacent to their territorial sea, in which they could claim sovereign rights and jurisdiction over the natural resources, both living and non-living, living resources of the sedentary species and the non-living, meaning the hydrocarbons and minerals. result was suddenly there were many overlapping territorial sea and continental shelf claims, and therefore a need to delimit boundaries. Now, some of the success stories, and a lot of this was led by Indonesia as the big brother in Southeast Asia. In northern part of the Malacca Strait and the Andaman Sea, from 1971 until 1980, many of the territorial sea and continental shelf boundaries were resolved, particularly continental shelf. Remember, that's not the water column, that's only the mineral and hydrocarbon. But Indonesia negotiated agreements with Malaysia, India, and Thailand. Thailand and India then agreed, India and Thailand, etc. There's a trijunction agreement between the three of them. So that part was rather resolved in terms of hydrocarbon resources. Indonesia also in 1970, before the Law of the Sea Conference began, negotiated a territorial sea boundary in the Strait of Malacca. From the southern half is a territorial sea boundary between Malaysia and Indonesia from Port Klang off Kuala Lumpur down to Singapore, and a continental shelf boundary in the northern part of the Malacca Strait. Indonesia also negotiated a territorial sea boundary with with Singapore. The first 6 points were agreed in 1970. It's subsequently been extended. So they were resolving the territorial sea boundary between them, which put greater certainty. In the Gulf of Thailand, after the 1982 convention, with great deal of confusion, great deal of overlapping claims, some archipelago or some strait baseline claims, which were arguably rather inconsistent with the Law of the Sea Convention. But what they ended up doing is negotiating agreements which under the Law of the Sea Convention are called provisional arrangements of a practical nature pending delimitation of the boundaries. This would be under Article 83 of the Convention. So they actually have joint development arrangements. It took a long time. It took 11 years. They reached an MOU between Malaysia and Thailand in '79. It took another 11 years to actually get an agreement. Then Malaysia and Vietnam, it was extended for a little bit here. Here's the Malaysia-Thailand joint development area. If you can see my cursor, it was then extended to Vietnam and Malaysia. That took only a very short time to negotiate. And then there's a joint waters agreement up here. So they're actually not boundaries, but they're provisional arrangements pending final delimitation of the boundaries. Now, Indonesia, if you just was the leader in terms of boundary negotiation in Southeast Asia before 1982 UNCLOS. There's a list of all the agreements that Indonesia entered into. It entered into many of them, some of us think, because it gave their neighbors more generous share of the continental shelf on the condition that neighbor recognized the claim to archipelagic waters under the Duanda Declaration. Now, then came 9 years of negotiation resulting in the '82 convention, UN Convention on the Law of the Sea. So I'm beginning part 2. The impact of the '82 Convention on Maritime Boundaries, there's 3 important things. One, the territorial sea limit was finally agreed at 12 nautical miles. In addition, a new zone between 12 and 200, an economic zone boundary was agreed, giving coastal states sovereign rights and jurisdiction to all the living and non-living resources, both within the water column and the seabed and subsoil below it. And then the definition of the continental shelf, which was not clear under the '58 Convention, was extended in effect or redefined to enable states to claim continental shelf resources beyond 200 out to 350, or in some cases beyond 350 to 400 or more. Now, another factor to keep in mind, the second major bullet point, decisions of the International Court of Justice and arbitral tribunals on the continental shelf delimitation put less emphasis than the earlier cases on natural prolongation. The earlier cases have sort of looked at the continental shelf as natural prolongation of the land territory. And Indonesia had earlier negotiated a treaty with Australia and the Timor Sea on the basis of natural prolongation. But then as the 82 convention was interpreted, much less emphasis was put on natural prolongation, which means it was more a question of equidistance between the two territories was emphasized rather than prolongation of the land territory under the sea. So Indonesia felt they were disadvantaged in having agreed to the natural prolongation concept in the earlier treaty. Here's what the law of the sea does. You start with your low water line along the coast, or your straight baselines or archipelagic baselines. You then have a 12-mile territorial sea where you have sovereignty. Then between 12 and 200 exclusive economic zone, it's not sovereignty, it's economic rights. It's the sovereign right to explore and exploit the resources in the water and under. And if you were blessed with a continental shelf that extended beyond 200, you could claim out to 350 or beyond with very complicated definitions, which we have no time to go into. But what this meant is that one of the major beneficiaries of the new law of the sea was Indonesia, because the archipelagic concept allowed you to connect the outermost points of the outermost islands, that red line, measure a 12-mile territorial sea from your archipelagic baselines. And then the blue shaded area is the economic zone that extends out to 200 miles from the baseline. And here you see it up into the South China Sea from the Natuna Islands. Now, I'll go over to one of the issues raised by the first speaker was fishing rights under Article 47.6. That special right, that was what I call the Malaysia provision in the Law of the Sea Convention, because it talks about waters in which two parts of a country are separated by the archipelagic waters of another. Well, until Timor became independent, there's only one place in the world where two parts of a country were separated by archipelagic waters, and that's between Western Malaysia and East Malaysia. So Article 47.6 is actually talking about rights of Malaysia to have fisheries and other economic rights in the waters between their two parts of Malaysia. And Article 51 is actually known as the Singapore Clause, which allows traditional rights in waters that were high seas, and under the new law of the sea became the archipelagic waters of Singapore or of Indonesia. Now, Indonesia maritime boundaries after UNCLOS entered into force, you entered into an agreement with Australia about the economic zone and certain continental shelf boundaries. Too complex to get into all the detail, but basically your economic zone, you negotiated that based more on equidistance from the territories and a different zone than from the continental shelf, which is based on natural prolongation. Then a very important agreement, you have a continental shelf agreement with Vietnam in 2003. You then had two subsequent agreements extending the territorial sea boundary in the Singapore Strait with Singapore. And then a very interesting concept of policy of Indonesia. With most of your neighbors, you first negotiated continental shelf boundary agreements, and now you're left with having to negotiate an economic zone boundary or a water column boundary. In the Philippines, you did the reverse. After several years of negotiations in 2019, the Philippines and Indonesia negotiated what is called an economic zone boundary. But in fact, it only covers the water column. It does not cover the continental shelf. And therefore, you'll have to have a subsequent agreement there covering the shelf. With your other neighbors, you have earlier continental shelf boundaries, which you do not want to agree to the same boundary for the economic zone. And therefore, Indonesia is one of the few countries in the world that is very comfortable having separate boundaries for the shelf and the water column. Now, I'll run to the South China Sea, which is I could speak about for 3 hours, I think. I'll try to summarize the major issues. The obstacles to maritime boundary delimitation. Here's the South China Sea. It's bordered in the north by China, island of Taiwan up here, then the Philippines to the east, Malaysia and Brunei down here, Vietnam to the west, and then Malaysia at the southern end, and then the Natuna Islands of Indonesia down here. Okay, now the big issues are the Spratly Islands, which are claimed in whole or in part by the Philippines, Vietnam, Taiwan, China, Malaysia, and Brunei. And the Paracel Islands, which are occupied by China, but also claimed by Vietnam. But it's this group of islands here which is the cause of the most difficulty. Here you see a quick map. All those occupied. This is the Spratly Islands. Those in red are occupied by China. Those in purple, many more, are occupied by Vietnam. Taiwan has one, Itu Aba, in the middle up here, which is the largest natural island they've occupied since 1956. All those in green are occupied by the Philippines. Down here off their coast, the ones in orange are occupied by Malaysia. China seems to claim all of them, plus the low tide elevations. Vietnam claims most of them. Vietnam claims occupies all of these over here as well. Brunei may be claiming the one out here and one here. So it's a very complex case in which the states cannot agree on who has sovereignty over the islands. This makes the boundary delimitation exceedingly complicated. It also makes it difficult to negotiate any kind of boundary, and unless you determine, are these islands entitled to economic zone claims? The Philippines is the second major archipelago in Southeast Asia, second largest one in the world after Indonesia. 2009, they finally brought their archipelagic baselines into conformity with the Law of the Sea Convention, claiming therefore the waters in the Sulu Sea as archipelagic waters. This is their claim of the Kalianan Islands in the Spratlys. This was a claim dating back to 1956. Here they're not claiming the waters, they're simply saying that the islands within this polygon shape they claim sovereignty over, and that they will be governed by the regime of islands in Article 121. So they're not claiming any well, they would claim a territorial sea from individual islands, but they're not claiming the maritime space between the inside the dotted lines. This is a major obstacle to sovereignty, and that's the so-called Sabah claim or North Borneo claim. This is the historic claim of Philippines to what Malaysia regards as the state of Sarawak in East Malaysia, and the Philippines, and recent comments by Duterte and the foreign minister of the Philippines, they're still claiming this. It's going to be impossible to reach a boundary agreement between Philippines and Malaysia as long as Philippines is still claiming part of the territory of East Malaysia as under its sovereignty. So this is a big, big problem in terms of both the adjacent boundaries for continental shelf and territorial sea. This is a map showing a snapshot. Here is the Indonesia's archipelagic baselines off the Natuna. They have a continental shelf agreement with Malaysia here, but no economic zone. This is the 209 Vietnam-Indonesia continental shelf. You're currently in negotiations for an economic zone. Similarly, this is the Malaysia-Indonesia continental shelf agreement with no economic zone. Here's where Malaysia's claim to a continental shelf is, but they've reached, I think, some agreement, but it's not publicly available with Brunei. The big problem is the getting agreement between Malaysia and the Philippines. Also, this claim would also affect any potential claim between Vietnam and Malaysia. Now, 2009, we never knew before 2009 whether any of the states bordering the South China Sea were going to claim an economic zone from the Spratly Islands. 2009, we had a hint because in order to claim an outer continental shelf beyond 200, the states had to show where their 200 limit was. And for the first time, when they made a joint submission for an extended continental shelf beyond 200, Vietnam and Malaysia showed the world by issuing maps with their claim to the UN, showing their 200-mile limit. This implied that they were claiming an economic zone only from their mainland land territory and not from any of the Spratly Islands. This, of course, and they did not claim beyond the continental shelf of agreement between Malaysia and Indonesia. So this was a great threat to the Chinese because this meant that if none of the islands are entitled to an economic zone, that means all of the gas and oil and fisheries are going to go to Vietnam, Malaysia, Philippines, and to a lesser extent down here from Natuna to the bordering states of Southeast Asia. And therefore, China, for the first time, one day after those maps were sent to the UN, made public their so-called 9-dash line map. And these dash lines, therefore, intersect with all or enclosed within them are all of the Spratly Islands, as well as seas which would be 200-mile economic zone from Natuna. And this has caused a great deal of whole series of diplomatic notes for the last 11 years. This is what the islands then look like. You have the Paracels, which is occupied by China but claimed by Vietnam. Pratas, which is occupied by Taiwan but claimed by China, so that's an internal China problem. Scarborough Shoal is an atoll claimed by the Philippines and China and Vietnam. But the major obstacle is here, the Paracels now, or the Spratlys. Now the South China Sea, the arbitral award said that none of these islands, it was in fact consistent with the practice of Malaysia, Philippines, and Vietnam. They said none of these islands is entitled to an economic zone of their own. Those that are naturally formed above water are only rocks because they cannot sustain human habitation, which means they get a 12-mile territorial sea but no economic zone. This is, of course, objected to by China. It seems to suggest it has either historic rights, and then they seem to also suggest they can draw straight baselines around these islands, although they haven't done so. So that's the major maritime disputes in the South China Sea. The law of the sea tribunal, or the arbitral award, resolved most of the issues, but China refused to participate and does not recognize the award. And this is my last slide. This shows that although Indonesia, it always tells everyone it is not a claimant state in the South China Sea. That is absolutely correct. That means that Indonesia does not claim sovereignty over any of the disputed islands in the Spratlys. The Natuna Islands belonging to Indonesia down here are not claimed by anyone else. Everyone recognizes that they belong to Indonesia. But Indonesia has a continental shelf boundary here with Malaysia, up here with Vietnam, but Indonesia claims an economic zone boundary beyond the continental shelf boundary. And this is what it's negotiating here with Vietnam. You'll have to negotiate this with Indonesia. But the 9-dash line intersects not only the economic zone claim of Indonesia, but also the continental shelf claim of Indonesia and its boundaries with its neighbors. This is why Indonesia is, if China is now saying, we were happy to engage in a boundary delimitation with you, Indonesia, let's talk. And Indonesia has responded by saying, thank you very much, but we know we have no overlapping boundaries with you, because Indonesia's made it clear in its diplomatic notes it does not recognize the legality of the 9-dash line. Therefore, as far as it's concerned, it has no overlapping economic zone or continental shelf boundary with China. It will admit it must resolve its economic zone boundaries with Vietnam and Malaysia, but it has nothing to talk about with respect to China. That concludes. Thank you very much. Happy to take questions.
Thank you for the presentation, Prof. Robert, which is very beneficial in our in opening our mind about the limitation of Southeast Asian maritime boundaries. And now allow me to welcome the last speaker, Ms. Emma Septaria, to deliver her presentation entitled Illegal Fishing Activities and its Settlement in Indonesia Perspective. The time allocation is the same, Mr. Emma, 20 minutes, and the microphone is yours.
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Can you listen to my voice?
Yes, we can listen to your voice clearly.
Okay, thank you. Good afternoon, everyone. So I'm so thankful today because the faculty giving me a chance to speak in this forum. It's such a great honor for me to be in one forum with Professor Beckman and Professor Otto and also Mr. Valentin. And let me share my screen. Can everyone see my screen?
Yes, yes, Ms. Emma.
Yeah. Is it clear? I hope it's clear.
Yes.
Okay. Okay, I'm going to talk about Indonesia perspective on illegal fishing practice. So under the serving president, Mr. Joko Widodo, Indonesia vision is to be the world maritime fulcrum that makes Indonesia a large, strong, and prosperous maritime country, and by restoring Indonesia identity as a maritime nation, safeguarding maritime interests and security, and empowering maritime potential to realize an even distribution of the Indonesian economy. And we can find the philosophical ground of the exploration and exploitation management of natural resources in Indonesia. First in Pancasila as the 5 guiding principles of Indonesian national life, and also in the Constitution of Republic of Indonesia, 1945, Section 14.3, Article 33.3, stating that the land and the waters, as well as the natural resources therein, are to be controlled by the states and exploited to the greatest benefit of the people. So this is the map of Indonesian maritime boundary after the independence. So one character that we can clearly see on the map is that Indonesia consists of many islands, 5 main islands, and many other small islands. And because of the governing law at that time was still Territorial Z Maritime Keringan Ordonansi 1939 from Dutch colonialization, Indonesia only had 3 nautical miles of territorial sea, and that makes there were high seas between and among Indonesia islands. And another special character of Indonesia is its location between Indian Ocean and Pacific Ocean and between ASEAN continent and Australia continent. By being located between 2 continents, Indonesia is also connected developed countries. A number of strategic straits of our economic lanes are also in Indonesia. Malacca Strait, Sunda Strait, Lombok Strait, Makassar Strait, and Ombay Strait. The strategic position of Indonesia's waters places Indonesia as a very important country of various area. However, with those 3 nautical of territorial waters drawn by normal baseline, while Indonesia coastline is not normal, put Indonesia in jeopardy. Why? Because there were high seas around Indonesia waters, and that allowed any ship, whether it's commercial or warship, could enter in and out Indonesia water freely. To protect Indonesia and all its nations and natural resources, the government issued a unilateral statement known as Juanda Declaration. Indonesia declared that all waters around, between, and connecting islands or parts of islands belong to the mainland of the Republic of Indonesia, regardless the size or width. It's part of the national waters and under the absolute sovereignty of the Republic of Indonesia. And Indonesia took 12 nautical miles of territorial waters measured by the outermost point from the outermost island at low tide. And also Indonesia ensured the right of innocent passage for foreign vessels as long as they sail in the way that do not harm national security. That action worried big maritime state, and they deemed the declaration was a gross violation of international law, violate the freedom of ship movements, and they were afraid that it had the potential to restrict the mobility of their naval forces and disrupt international shipping. The protest didn't stop Indonesia in performing a United States with its archipelagic concept, and even moving forward by enacting the law number 4 of 1960 on Indonesia waters, giving the legal force to Juanda Declaration. In 1980, Indonesia declared its exclusive economic zone for 200 nautical miles, and this action was taken by some other states and also got protests from big maritime states. After a long diplomacy, the concept of archipelagic states was accepted by international law, and under Part 4 of archipelagic states, the concept of archipelagic states was recognized by the international law. The consequence of claiming those waters, I mean the EEZ and the 12 nautical miles breadth of territorial sea, Indonesia waters added vastly from around 2.5 million square kilometers to about 5 million kilometers square. And under Indonesia waters, there are 37 of fish species all over the world, and some of them have a high economic value. And so far, Indonesia hasn't been able to utilize all of the potential because of many factors. And then illegal fishing practice began, mostly by neighboring states. And from the map, we can also see that Indonesia has 10 neighboring states bordered by the sea, a small part of land border are only on Sebatik and Papua New Guinea. Sorry. And Timor-Leste. And what is illegal fishing? The definition of illegal fishing can be found in International Plan of Action on IUU Fishing, stating that any vessels from any country on territorial waters under the jurisdiction of a state fishing without permission or fishing in violation of the local laws and regulations, or any vessel sailing using flag of country members of regional organization on conservation and management of fishing concerned, and the practice is in violation of provision on conservation and management of the organization where the country is engaged, in violation of international law, and in violation of national laws and international obligations. In Indonesia, the definition of illegal fishing can be found in the Ministerial Regulations of Marine Affairs and Fisheries number 37 of 2017, stating that a fishery activity which is invalid or fishery activity which is carried out against the governing fishery laws. So from the maps, the prior maps, we can see that the gate to come in Indonesia is 99% the open sea, which can be guarded by national naval fleet. And for maritime borders, there are still several segments that needs further negotiation and that leave some creeping jurisdiction area, as mentioned before by Professor Beckman, that there are obstacles or challenges in delimiting maritime borders. And for Indonesia, the obstacles are the political condition of neighbors and the different interpretation of legal principles applied. And the view of single line from several states, seeing the line of EEZ and the continental shelf are the same, while they are not always to be the same. And talking about illegal fishing, maritime border becomes important, as to decide a fishing practice is legal or illegal, there has to be a fixed border. And to eradicate illegal fishing, the governing laws is law number 31 of 2004, as amended by law number 45 of 2009. The law regulates those who run activity in fisheries sector like fishing, whether for small scale and large scale fishing business, or those who transporting fish, exporting fish, doing aquaculture business, have to have license from Indonesia government. And the law also elaborates fishery crimes and the sanctions. The law provides possibility for foreigner to take a part in such business, and all of the activity has to be in accordance with the governing laws and regulations and policies in Indonesia. Furthermore, the laws also mandates government to perform the fishery courts as a special courts for special crimes in fisheries. The sanction for those who violate the regulations are administrative sanction, fine, and imprisonment. Exception for the fishery crimes conducted on the exclusive economic zone. And any articles on this law is in line with what Law of the Sea Convention states. The judicial process of illegal fishing case in a fishery court. So once a case of illegal fishing found, the investigator is done by the investigators, and once the document complete, then the document will go to public prosecutor, and then it will go to fishery court for a trial, and then the judge make a decision. If no party complain, then it become incorrect, or if there is a claim from a party, then the party can take legal effort to the appellate court. The exclusivity of the fishery court are the investigators come from different agencies, namely Supervisor of Marine Affairs and Fisheries, investigator from National Naval, and investigator from National Police. And all of them have to pass special education and technical training in fisheries. And for the public prosecutor handling illegal fishing, directly appointed by Attorney General of Indonesia, and they also have to have special education and technical training in fisheries. For the judges, the panel of judges consists of 3 judges, 1 from career judges and 2 from ad hoc judges coming from kinds of agency, and also have got special education and technical training in fisheries. So far, Indonesia has 10 fishery courts all over the nations. So this is the fishery crimes that went to the fishery court in Indonesia, and during 2014 to 2018. So we can see that the graph went up from 2014 to 2015, and it increased rapidly to in 2016 and keep going up in 2017. And the number of fishery crimes slightly went down in 2018. So as the trend of illegal fishing went up, sorry, I'll skip that graph. Yeah, as the trend of illegal fishing went up, the government set a strategy policy to combat illegal fishing. First, in 2014, Indonesian government issued the ministerial regulations which stopped the license of ex-foreign fishing vessels. And in the same year, the government also prohibited the transshipment at sea to go abroad. And then there was a prohibition to take some species of fish, and yeah, that was the policy. And in 2015, the government formed the Task Force 115, and in a year later, the government ratified the Port State Measure Agreement. Also, Indonesia government restrict the fishing business only for domestic investor. Why did Indonesia government stop the license of ex-foreign fishing vessels? Based on the data from analysis and evaluation that is conducted to more than 1,000 ex-foreign fishing vessels, 100% of them had been involved in IUU fishing violation, and the vessels have operated around Riau Islands, Bali, Maluku, Sulawesi Utara, Papua Barat, and Papua. Moratorium also eases the analysis and evaluation of ex-foreign vessels. Ex-foreign vessels have a large capacity, about 200 to 600 gross ton, with a fishing gear exploiting marine natural resources that causing the depletion of Indonesia's fishery resources. And analysis and evaluation can be a basis for developing new policies in the fisheries sector, which are based on the finding of the fact in the field. And analysis and evaluation aims at knowing the level of operational compliance of ex-foreign ships, knowing the modus operandi of the way of fishing crimes and other related crimes that are carried out by illegal fishing practice, understand the root of the problem and the weak points of policies and laws and regulations. And transshipment is also prohibited because transshipment open the gate of illegal fish export and unreported fishing. Another policy is joint communique. So Indonesia has initiated joint communique on mutual understanding and cooperation in combating illegal, unreported, and unregulated fishing of living marine resources and promoting the sustainable fisheries management with 22 countries, namely America, United States of America, England, Norway, Denmark, France, Russia, Dutch, Chile, and Australia, Timor-Leste, Papua New Guinea, Palau, Japan, India, South Korea, Sri Lanka, Bangladesh, and Vietnam. And Africa, also Middle East. because the trend of the practice of illegal fishing increase, even if the moratorium has set out. In 2015, Indonesia, the government performed the Task Force 115, as the eradication of illegal fishing requires extraordinary law enforcement efforts which integrate intergovernmental agencies, utilize the latest technology, and have a deterrence effect to the actor, as well as being able to return state losses. So government thought that the formation of a task force 115 is a must. And the main task of task force is to develop the implement of enforcement in the eradication of illegal fishing through cross-agency coordination. Illegal fishing in COVID pandemic. I think I have to share this because I thought at first the actors will be also afraid of the virus, but the data shocks us that the graph is also going up this year. And it shows us despite all of the efforts Indonesia has done, the practice of illegal fishing still happens. Once the control is weakened, the perpetrators will begin to operate again. And challenges that Indonesia meets in combating IUU fishing, first, the maritime borders, which have not been set. And second, the low understanding on illegal fishing. And third is limited infrastructure. And despite of the challenges, Indonesia keep doing the effort and actively cooperate with national and regional agency, national, regional and international organizations. Here, Indonesia is the members of International Monitoring, Control, and Surveillance, and also the member of Implement DEC regulation, and also the global, and also have cooperation with Fishing Watch. And Indonesia becomes a party of law of the Sea Convention, the compliance, the fish stock agreements, the code, the International Plan of Action of IUU Fishing, the Port State Merger Agreement, and the high-level panel. And in regional, Indonesia become member of Convention on Conservation Short-term Bluefin Tuna, ASEAN Regional Forum, Indian Ocean Tuna Commission, Multilateral High-Level Conference, the ratification of High Seas Fisheries of UNIA, and Western and Central Pacific Fisheries Commission. And also Indonesia campaigned that illegal fishing is a part of transnational organized fisheries crimes in many forums. I think that is all that I can share today. I hope that I'm waiting for the questions, and maybe we can go in detail in the question and answer session. Thank you, Ibu Aska. I offer you.
Thank you, Miss Emma, for giving such intriguing and interesting presentation. And ladies and gentlemen, now we come to a question and answer session. I'd like to have 3 questions from the participant. And I invite the participants to ask directly to the presenters first. Please, if you want to give a question directly, I give the opportunity. Okay, Prof. Ramsan, please, microphone is yours. Please unmute first, Prof. Unmute the microphone.
Is that correct?
Yes, we can hear your voice.
Yes, my name is Hamad Ramson. I'm from Faculty of Law, University of Sriwijaya in South Sumatra, Palembang. Yes, I would like to address my question to Mr. Valentine. Yes, Mr. Valentine, you are discussing about an SEZ, right? Yeah, because I forgot. You are discussing about the historical fishing right? Yeah. My question is about in the ECZ area. Is there any historical fishing right? Because 200 nautical miles belong to the coastal state. Yeah. So that is my question.
Thank you for your question. So if I understood it correctly, you are asking whether there could be historic fishing rights in the EEZ, right?
Yeah, that's right. That's right. Yeah, that's right.
Well, yes, as I mentioned earlier, in principle, I don't think there could have been pre-existing historic fishing rights in areas that are now covered by an EEZ, because those areas form part of the high seas. And as I said earlier, in the high seas areas, it's virtually impossible to acquire historic fishing rights.
Mm-hmm.
Now, a different question is whether new historic fishing rights could have been acquired after the emergence of the EEZ as a legal concept. And there, I think it cannot be ruled out if a non-coastal state authorizes its vessels to fish in another state's waters. Of course, in principle, that's IUU fishing, it's unlawful, but assuming that the coastal state does not protest and does not react in any manner, does not enforce its laws, and in the event that this behavior amounts to acquiescence, so implicit acceptance of the coastal state, then in principle, I think it is possible to acquire new historic fishing rights. However, this would also require a significant amount of time, and it would have to be a case-by-case assessment, of course, taking into account the conduct of both states and any reactions of the coastal state. And as soon as the coastal state says, no, this is illegal fishing, there's no way for the other state to actually acquire such rights, in my view. Now, there is currently one case pending before the ICJ that might bring further clarity on this issue. It's a case between Nicaragua and Colombia that is currently being heard. And it's about, inter alia, it's about historic or traditional fishing rights in the Caribbean, in an area that is disputed between the two states. In fact, it's an area where the ICJ has already given to Nicaragua in the maritime delimitation. However, Colombia, in a counterclaim in that case, claims that Colombian fishermen still have rights to fish in that area. And so this counterclaim will give the International Court of Justice the opportunity to also say something about historic fishing rights or traditional fishing rights in the EEZ. And I think we can expect, well, Corona probably postponed the judgment a little bit, but I think the hearings, the final hearings should be relatively soon. And I guess we can expect a judgment sometime in 2021 or maybe early 2022. So maybe that will finally settle the issue in the sense of authoritative jurisprudence. Thank you for the question.
Sorry, actually, Indonesia fishing is about the fishermen from Thailand. They always claim that to catch the fish in the Indonesian territory based on the historical fishing rights. Yeah, right. So I don't understand though. This is why do they claim historical fishing right while the Indonesian government has already the limitations of 200 EZ, right? Yeah. So it is a really a problem for us, how to overcome this historical fishing right claim by other Asian countries, right? Yeah. So I have no idea how to handle it.
Yeah, I
Because
mean,
they use the claim.
yes, of course. In principle, a historic fishing right it's a kind of an exceptional claim in another state's maritime zone. So it's not always completely impossible to have such rights. So you need to check that on a case-by-case basis. So I can't comment on each and every claim that the Thai fishermen might bring forward. But at least when, with respect to the archipelagic waters, there could be a claim to traditional fishing rights, although Thailand is somehow, it could be very well disputed whether Thailand is actually an immediately adjacent neighboring state of Indonesia. I think it's one of the more doubtful examples. So it's quite possible that Thailand can't even rely on Article 51, paragraph 1 of the convention. So even that's out of the question. And as far as the EZ is concerned, I agree with you. There is, in my view, no legal basis. But of course, there are other scholars who think that traditional fishing rights can exist in the EZ. And as long as this question is not completely settled and everyone agrees, as long as this situation continues, I think there will always be states that will try to rely on this doctrine to justify continued access. But then it is for the coastal state to enforce its laws very strictly and to push back in terms of enforcement and diplomatic exchange.
Yes, that's right. Yeah.
Or bring a case against the other state before an Annex 7 tribunal or the ITLOS.
Yeah, so far I know there's no cases brought to the tribunal in this case. Okay, can I ask another question for the committee to ask? And I would like to address my question to Mr. Beckman. Is it okay?
Okay, please go on, Prof.
Yes, because I'm focusing my study on the South China Sea. Yeah, right. South China Sea is a very conflicting area, for the country, for the coastal states in the South China Sea. The problem faces by the country because they have their own delimitation, from Spratly Island to the country. So every country in this area have their own perspective over the limitation. What is your opinion, Mr. Beckman? How to handle this problem?
Well, I have no opinion on how no solution in mind, but I think you should be clear that the Malaysia, Vietnam, Philippines are not claiming any economic zone from any of the Spratly Islands. They're claiming their economic zone only from their archipelagic baselines. In the case of Philippines, they're from the straight baselines along the coast from the Vietnam and Malaysia. So their economic zone claims are consistent with the Law of the Sea Convention. The country that seems to be, again, China has a deliberately, in my view, deliberately ambiguous position legally. On one hand, it seems to suggest it has a right to claim an economic zone from the Spratly Islands, notwithstanding the arbitral award. And then it also seems to suggest at times that it has historic rights within the 9-dash line. Again, even though the arbitral tribunal stated that it did not have any such rights, that if they had any historic rights prior to the 1982 convention, they relinquished those rights when they became a party to the convention. So, but you have a problem that for domestic political reasons and for economic reasons, China is going to continue to assert the right to fish in that area. It looks like it may also continue to interfere with hydrocarbon exploration by other countries. So the question is what the Southeast Asian countries can do to counter what they all agree are illegal claims of China. Can I make one comment on the previous question as well,
Yes,
on
yes,
Thailand?
yes.
Thailand, I think Thailand, the lawyers do not claim they have historic rights. The problem of Thailand, it was the largest long-distance fishing country in Southeast Asia before the 1982 convention. And when the 1982 convention was agreed, most of the historic fishing grounds of Thailand became the economic zone of Myanmar and Bangladesh and Indonesia and Malaysia and Cambodia. And therefore the result is the Thai fishermen continue to fish in their historic waters, even though those waters now are the economic zone of other countries where they have no right to fish.
Okay. Okay, it's quite clear, Mr. Beckman. So my very last question, please allow me to ask one more question to Ibu Emma, I suppose.
Okay.
Yeah.
Okay, please, Prof.
Yes, thank you very much for the last time. I'm very shy to ask this question because many questions I ask here. But anyway, Ibu Emma, so far I know that we have many problems about the limitation, right? So especially one case is now brought to the International Court of Justice when we are fighting for Malaysia and then we lose. And the second one is about another island in not so far from Kalimantan. So what is actually a real problem for us, once the case is brought to ICJ and then we lost it. And the second one, we don't want to bring it to the ICJ and then up to now there is no news about this. So what is the weakness of our policy in terms of, delimiting our sea actually? So yeah, that is only my comment, or maybe you can answer it or anyway. So thank you very much.
Okay, Bu Emma, the microphone is yours.
Prof. Ramson, finally we can meet on the screen. I tried to respond to your questions. Well, I have no idea what is going on ICJ for our no news for our, what is that? The case, right?
Yeah, the second one case has no news up to now.
Yeah. And for the delimitation problems, as I mentioned before, like this is one of the example, right? Indonesia and Palau, their EEZ are adjacent to.
Okay.
And until now, we cannot set the borders because Indonesia and Palau has different perceptions or different interpretation of the method that will be used. Indonesia want to use equidistance, if I'm not mistaken, while Palau want to use another method. Each method, of course, has advantages for each state. And as long as the interpretation did not meet one each other, I think well, maybe another or further negotiations have to be made. Yeah.
Okay.
Yeah. So that's the obstacles of delimiting our maritime borders. And another thing is there is still the view that the borders of EEZ have to be the same with continental shelf borders, while it's not always have to be the same, and the law of the sea itself open the different way of that delimitation. I hope that yeah, that can
Yes, I can catch
answer
it.
your question.
Yeah, what I was thinking right now, rather than conflicting with the two countries, there's no settlement like that. So why don't we propose to bridge cooperation, in the conflicting area, rather than bring the case to negotiation or bring the case to the ICJ? It has no result yet. So why don't we bring a cooperation? What do you think?
I can say that again, Miss Prof. Romson. So that will be. I mean, if we go that way, then we will get the solution sooner.
Mm-hmm.
Yeah, that's
Yeah.
that's my
Okay.
thought.
Okay, thank you very much then. Bye. So it is very nice to meet you all, guys. Yeah, I hope I can still get.
Yeah, thank you.
Okay, thank you, bro.
Okay, bye.
So I know we'll move to another question to another presenter. I found the question from Mr. Valentine to Professor Beckman. Is Indonesia seeking to establish a regime of superimposed EEZ of two different coastal states of Natuna, like the 97 bird treaty between Australia and Indonesia? So the question is for Professor Beckman. Please,
Well,
Professor.
if I understand Indonesia's position, it is that it's in the midst of negotiating their treaty with Vietnam. They've had many negotiating sessions already. Indonesia's position is there should be an economic zone boundary governing fisheries, which is not the same as the continental shelf bound that would govern hydrocarbons. So Indonesia is comfortable with two different boundaries, as in the case between Australia and Indonesia. And I think that's also the case with Malaysia in the upper half of the Malacca Strait, and probably also near Natuna, where Indonesia, I think, felt that they were very generous in giving economic continental shelf boundary, in agreeing, because the part of that negotiation was recognition in some cases of the archipelagic waters. So Indonesia says it's fine for us. We are comfortable with one boundary for seabed and one boundary for the water column. And the other states, whether it be, I think, Vietnam or Palau or Malaysia, are pushing for a single boundary, having the same boundary. So that is what is my understanding of what is holding up the negotiations. But Indonesia has a very good team of negotiators. I think they will, and so does Vietnam. I think they will work things out eventually. But sometimes it takes many, many years.
Thank you.
Okay, thank you, Prof. Beckman. The last question is for Mr. Fountain. The short question is the each PR or historic fishing right also exists in the area of EEZ? That's all. Please, microphone is yours, Ms. Valentine.
I'm not sure I understood it correctly. Is the question whether there can be historic fishing rights in the EEZ? Because
yes,
I think that question was already answered.
Is the historic fishing right also still exists in the area of EEZ?
Yeah, well, I think I've already answered that question. So in the first place, I think there probably weren't any in the high seas areas now covered by an EEZ or EEZ. Or was this, or did the question, the person asking this question refer to the European Economic Community and not the EEZ? Just to be sure.
Oh, yes.
It's the EEZ, right? The question relates to the maritime zone, not okay. Well, in that case, as I said, I don't think there were any such rights in the first place in the high seas areas now covered by EEZ. And secondly, I don't think the idea of pre-existing historic fishing rights would be compatible with the EEZ regime. So in any case, they would have been extinguished in my view.
Thank you to the all presenter. So now we enter the final session in this event, particularly the conclusion of each speaker. Each speaker has 2 minutes. The speaker has 2 minutes to warm up the speaker's idea. 2 minutes ahead is yours, Prof. Robert Beckman.
You want me to summarize or want me
Yes.
to have some concluding comments?
Okay.
I guess the major problem facing Indonesia with respect to boundaries is the problem with China and the problem in the South China Sea. And the question there is that Indonesia's position is there are no overlapping EEZ or continental shelf claims, because although China occupies some of the islands or claims all of them in the Spratly Islands, as the tribunal ruled in the South China Sea case, none of the islands are entitled to an economic zone, and therefore there is no overlapping boundary to be negotiated. The problem, of course, is that China does not recognize the award, and for domestic political reasons, it is likely to continue to assert rights. And then it's a question where Indonesia stands together with Malaysia and Philippines and Vietnam in trying to oppose the claims of China. And there's no point in trying to take this to a tribunal, or maybe they perhaps should at some point. But China has already shown in the South China Sea case, it was not like, even though it is technically legally bound by the decision, it has simply declared the decision of the tribunal null and void, and it has refused to follow it. So that questions also the efficacy of the dispute settlement process in the convention. So it's a very difficult problem. My only suggestion would be Indonesia should work together with the bordering states of the Southeast Asia, of the ASEAN member states, in trying to work together to negotiate with China on this issue. Thank you very much for inviting me. I hope that my contributions, I hope people benefited somewhat from my contribution.
Okay, thank you for Professor Beckman. So now is for Mr. Valentin, 2 minutes to wrap up the conclusion of your presentation.
Just on time for me. Okay. I think I would simply mention that as far as the doctrine of historic fishing rights is concerned, my view is that the problem is less about actually legitimate interests, or in most cases, less about legitimate interests of traditional fishers, but more so about the need for some states, or the intention of some states like China, to make use of this exceptional concept in order to justify claims that would not otherwise be lawful under the law of the sea. And I think this is the reason why we are seeing somewhat of a renaissance of this doctrine of historic rights more generally, where various states try to use it in order to justify claims that would not otherwise be lawful. And I think historic fishing rights are no exception here. We see this with Russia and Ukraine in the Sea of Azov. We see it with Colombia and Nicaragua. We see it in the context of Brexit, in European waters again now too. So I think the problem here is less that there are real interests at stake, but it's more about power politics. It's about justifying claims. It's about exerting pressure on neighboring states. And I think for that reason, the whole discussion about the doctrine of historic fishing rights or historic rights in general is somewhat over or emphasized. And I think the solution does not lie in these concepts; it lies in the political dynamics that are behind these strategies that states employ. And I can only urge them to get back to the table and negotiate reasonable deals. For example, if I just briefly, I just mentioned Brexit. Often these sorts of strategies come up where both sides are pretty strict in their approach. But I think sometimes, and we can also see this in the Brexit context, it's better to simply find a practical solution that has, for example, a phasing out of a pre-existing access in order to make to reduce the negative impact on the fishing industries of your neighboring states, and perhaps sometimes where both sides can benefit to even allow for reciprocal access or even just normal access in return for some remuneration in order to have good neighborly relations and in order to not heat up nationalist agendas. So yes, these would be my final thoughts on the issue of historic fishing rights. Thank you very much again for your invitation, and it was a pleasure being here today with you.
Okay, thank you, Mr. Valentin. Now is Mr. Emma's turn. Please 2 minutes to conclude the idea.
Okay. Okay, thank you, Ibu Aska. Well, I can come up with one conclusion that the world has only one ocean connecting state by states, and sustainability of fish stock will affect other regions. Thus, illegal fishing, as it is very organized crimes, involve many parties like flag states, market states, flag of convenience states, and coastal states. It has to be combated for the world prosperity and the world security. And thus, it needs cooperation from every state. And there has to be a mechanism control in every cooperation to evaluate state compliance on what has been agreed. That's from me. Thank you. Thank you for the time. Thank you for every attention given to this forum. Good afternoon. Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Waalaikumsalam. Waalaikumsalam warahmatullahi wabarakatuh, Ibu Emma. So now, ladies and gentlemen, we finally come to the end part of International Seminar. Before I close this seminar, I would like to thank you so much to the speakers for informative and interesting presentation, and to the participants for very active participation. As moderator, I apologize for any mistakes during the agenda. Hopefully, we can coverage on another agenda in discussing existing issue related to the law of the sea. Of course, when the pandemic is over. Please give applause for the presenter and for all participants. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you, Prof. Robert. Thank you, Prof. Ramsan, Bu Emma, and all participants.
Thank you, Prof.
Thank you,
Beckman,
Robert.
Prof. Valen.
Thank you, Prof.
Thank you, Prof.